by following up on the point about enforcement and the approach taken. And really, it's a lesson in how focusing on one part of the regulations can put entirely from your mind another part of the regulation.
Right.
The Lordships will find a list of a little clip of pages on your desks, and it starts with the a list of all the regulations in the SIL regulations.
Yes.
And behind it are regulations 95 through to 107, which form chapter 3 of part 9 on enforcement, and which in the time available I just had copied as a whole, and put before the court. And in the way of these things, SIL began as English and Welsh legislation.
Yes.
The clip that your Lordships have shows some divergence between the two, and those regulations that I've put a line through very quickly are those where it's the Welsh law, so just for the purposes of clarity. And I propose, if I may, to go through this clip very quickly.
Yes.
To draw attention to the approach taken to recovery of SIL by the regulations themselves. So starting with Regulation 95, some of the terms used in the chapter are defined, and I just touch on Schedule 12, because this is one of the definition of Schedule 12, because this is one of the areas in which England and Wales now diverge, and it provides that distress against goods can be, in England, should be undertaken, if appropriate, under that procedure as so defined. Now, 96, so the authority, just to indicate where I'm going, the authority has a number of choices how to recover SIL if it remains unpaid. The starting point, generally speaking, is to seek a liability order. And we see 96, Regulation 96 indicates that first things first, a reminder notice is required, and then following a reminder notice, an application may be made under Regulation 97. It's made to a magistrate's court by complaint, and your Lordships will see Regulation 97, 5 and 6, that the granting of a liability order is mandatory where the circumstances which justify it are made out.
Which provision is that, sorry?
Regulation 97,
yeah,
subreg 5 and 6. The court must make the liability order if it is satisfied that the amount has become payable and has not been paid, and an order made must be made in respect to amount equal to the outstanding amount and costs. So that's an administrative step taken to obtain a liability order from the magistrate's court. The other option is to distress, to take control of goods, as it's put in England, Regulation 98. And
that's not another option, that's a sequential step. That's not another option, you've got to get your liability order first.
That may be right. I'm not absolutely sure.
Well,
oh yes, where a liability.
It's what it says.
Yes, thank
you. It would be an option to...
I'm just picking up your term of option.
I mean, it would be an option whether or not to do it, but you could only do it where a liability order has been made. Yeah. They don't have to do it. They don't have to go on to take this further step.
That's absolutely right. 99 and 100. 99 is repealed in England. 100 indicates that the collecting authority may apply for a warrant committing a debtor to prison where that attempt to enforce using the Schedule 12 procedure was effectively unsuccessful, and C, the authority is able to demonstrate to the court that it's unable to recover the amount payable by the debtor by means of a charging order. So that flags up the option of a charging order under 103. So I'm going to put on one side commitment to prison, a discretionary route in those circumstances for the moment, and skip over therefore 101, which is further provision in relation to the commitment to prison, and come on to 102. Some short provisions about the constitution of the Magistrates' Court there, which I just draw attention to, and then charging orders at 103. Again, in this case, if it's the authority's intention to seek a charging order, they do need a liability order first. So the liability order doesn't itself give them the money. They then have the option of seeking, by application to the appropriate court under Regulation 103, where a magistrate's court has made one or more liability orders, and the amount mentioned of which the liability order was made effectively remains liable, but it remains unpaid. And at the time the application, this is C, 1C, at the time the application under this regulation is made, at least £2,000 of the amount in respect of which the liability order was made remains outstanding. The application which may be made to the appropriate court under this regulation is an application by the authority concerned for an order imposing a charge on a relevant interest to secure the due amount.
Oh.
And before making the application, again, the debtor must be notified. Notification must be in writing. Subrule 5 must be sent to the debtor and any other person the authority considers may be prejudiced, and certain other sort of administrative matters.
So far, this is all premised on there being a liability order.
Indeed.
For which the critical provision is... No, but the critical provision is 97.5. The Magistrates' Court has to be satisfied that the amount has become payable. And so that, I mean, fascinating as this is, and I'm grateful to you for finding it, but that doesn't really answer my Lord's question as to whether the person who is the defendant to the application for a liability order can say that the amount has not become payable because there was a breach of Regulation 65.
I was hoping to answer the point, and I'm too slow for your Lordship, clearly, but I'm coming to 104 and indeed 107, in which the regulations make it very clear, not in relation to liability order, I absolutely grant your Lordship, but in relation to the charging order, 104.1, in deciding whether to make a charging order, the court must consider all the circumstances of the case, and in particular any evidence before it as to the personal circumstances of the debtor, and whether any other person would likely be unduly prejudiced by the making of the order. So there's a qualitative judgment there before making the charging order, and the court, and subrule 4, the court by which a charging order was made may at any time on the application of the debtor or the collecting authority make an order discharging or varying the charging order. And that would be the route, but my point being simply that at that stage the circumstances of the debtor are taken into account. But again, I do understand that I'm not addressing head-on the Wandsworth and Winder point. I was hoping to show that in a sense we don't need Wandsworth and Winder because the statutory scheme does provide for a qualitative judgment before a charging order is made. So perhaps I'm ducking the question. I having found this, I may put it this way, I haven't had the time to look into and reliably make submissions to your lordships on whether in one circumstance or another the defendant would be able to raise effectively a judicial review argument in defence to any one of these applications. I wouldn't rule it out, and I do submit that this is peripheral. I see why it's come up, because it goes to the question of potential prejudice from the retention of the notice. But I'm sort of doing my best with what I have in the time.
That's very helpful. I was actually going to ask you a different question, which is the appropriate court where the charging order can be made?
That is the county court, as I understand it, and then there's 107 is also important. Now 107, as I indicated to your lordships before the luncheon adjournment, the liability notice is a local land charge, and the regulations do allow the enforcement of that local land charge.
So 107 does not depend on a liability order.
Indeed. But sub-rule 5, I'll jump straight to it. In deciding whether to grant consent to enforce the charge, the court must consider all the circumstances of the case, and in particular any evidence before it as to whether any person would likely to be unduly prejudiced by enforcement of the charge. So it was that provision which, if that is the route that the authority chose to take, instead of going through liability order to charging the land, might go via enforcing the local land charge directly, then that would be, in my submission, specifically dealt with under sub-rule 5, and one wouldn't need a Wandsworth and Winder type argument to bring up the unfairness of pursuing the matter. But these things can depend on the specific circumstances of the enforcement, the moment of enforcement, and the conduct of the parties up to that date, up to that point. So I wouldn't want my submissions in this court to, as it were, bind the council in any future enforcement that it was required to pursue against this appellant. It's an indication of my best attempt at a view of the law in a general sense, without prejudice to submissions made in the particular circumstances of where prejudice lies in the given case. I hope that.
Yeah, no, that's very helpful. Is there actually any commentary on this in any textbook?
Not that I'm aware of.
No, right.
And I write the SIL textbook for the SIL chapter for LexisNexis.
Right.
And I haven't found any learning on this. Now that it's come up, there may be.
Well, I don't think we are promising. I don't think we are promising a definitive analysis of it for the purposes of determining the appeal before us. It may be necessary to touch on it.
But returning to the root, the reason this came up, I do submit that the court should be looking for actual prejudice, not risk of prejudice in the future. And if and only if either the appellant doesn't pay the SIL that he's known since 2018 he would need to pay, or the council, the collecting authority, suddenly reverses its hitherto very reasonable position in relation to added charges and decides to backdate interest or make a charge that isn't properly due.
Yes, I mean, there may, I'm not saying it's this case at all, so that ought to be noted. But there may be circumstances in particular cases resulting from the difficulties encountered by the economy and particular businesses within the economy during the COVID pandemic, which would call for an application of these provisions that heeded those circumstances. I'm not saying that was the case here at all. It's not for us to delve into that, but there may be such cases. I don't know.
So an interesting point, but
No, I'm not asking for a response. I'm simply making the observation that that might be, as it were, a practical illustration in prospect of the application of 1075. I don't know.
So
right. Well, no, that was a helpful exercise. Thank you, Ms. Townsend, for that.
Good. So
we'll put that. Let's put that in its rightful place, which is in the bundle.
It might usefully go in the authorities bundle at tab. Is it 2?
Yeah. No, put it in. We'll put it in at the end of 2, I think. In case you need to refer to it again, that's where we'll find it.
For some reason, I don't have tabs in any of my bundles.
Oh.
I'm not complaining, but I just wanted you to know that I don't, because I don't know where to put it in.
Right. It follows page 79.
So try and bear that in mind and give page numbers, which
Yes, would you?
is an inadequate but better option than tab.
Thank you.
We're looking at the pagination in the top right of 333, I think.
Yes.
Because there's dual pagination on some pages.
Yes.
Right, so where are we?
So where I thought I'd go next is to the chronology, because the learned friend understandably starts in 2020, but it is worth, in my submission, just recalling how much went before. And my skeleton deals with this. I'm going to hopefully trot, but at least walk at a reasonably brisk pace through paragraphs 21 and following.
Of your skeleton?
Yes.
Right, okay.
So we know what the site is, that's paragraph 21. We know that Mr. Bennett, who's an architect and has acted as planning agent and also contract overseer as far as the development's concerned for the 2 appellants throughout the relevant period, and he describes his role in his witness statement. I do ask your lordships just to turn that up. It's page 178 of the supplementary bundle. Curious is that nowhere does he acknowledge his own prior knowledge that Sill was payable. Something that isn't clear from this statement is that Mr. Bennett ensured that Sill Form 1, which tells the council what it needs to know in order to charge Sill, was completed for the 2017 permission. But what he does say, which is relevant to timing and we'll come on to, it is paragraph. It starts at paragraph 16 about his role and the legal advice obtained.
Paragraph 16, yeah.
Yeah, paragraph 16. He quotes what the council said at the time it was in imposing the surcharge. And sorry, I need to go back to 15. What he doesn't say at 15 is that he had acknowledged at that time his client's willingness to commit to paying SIL. And that's an important aspect of the chronology, if I may say, found at page 135. So leaving a finger in Mr. Bennett's witness statement, please. Would your lordships go to page 135, which is halfway through his email to Lorraine, the SIL officer at the council.
Mm-hmm.
And at the top of 135, he says, they, referring to his clients, remain committed to the SIL liability, and he spells it out to the penny, but require some flexibility in the council's response relative to the disruption that COVID-19 has caused within the construction industry.
Right, so that's the date of that is
29th of December 2020.
right.
They remain committed to the SIL liability.
Yeah.
Turning back to his witness statement, paragraph 17 begins, the legal advice, which I'm not absolutely sure from this witness statement when that was obtained.
Well, I think you're told in 15 that he advised the first claimant to obtain legal advice, which was sought in January 2021.
January. Yeah, but okay, in January 2021. So that confirmed what was apparently his view, that the liability notice issued 16 months after the grant of permission had not been issued in accordance with the SIL regulations. And we prepared and submitted with the assistance of Burkitt's an appeal under Regulation 117. So if not already absolutely clear from the learned friend submissions, perhaps it was, if it's an excuse, which in my submission it's not, to know nothing and not investigate the legality of the liability notice for 6 months, nevertheless we know that in January 2021 the appellants received legal advice that it was not in accordance with the regulations.
I noticed the word now in the following line, which was the only mechanism now available to challenge the irregularities in the council's position. I don't want to read too much into it, but I thought that there might be some significance in the word now.
Perhaps somebody expressed the view that judicial review is too late. Perhaps.
Sorry, I'm being very slow. Yes, I've found it, sorry. Yeah.
He also says, is this fair? Legal advice subsequently confirmed my view.
Indeed.
Which suggests that he had a view before the legal advice, but I don't think he tells us when he formed it.
Indeed. Or when, or whether it was before or after his explicit commitment to the payment of SIL on the 29th of December.
No, he just doesn't tell us at all.
So I said I'd go through the chronology, and I jumped straight to the end of December and the beginning of January. Such is life, I apologise. 22 of my... Mr. Bennett's witness statement we can put on one side for the moment.
What is, just before we go any further, what is the submission to which this leads?
No excuse for the delay.
Right. Yeah, do carry on, thank you.
That's their delay, not your delay.
You often know...
Any is the joke I could have thought to insert in this case.
No, but actually, we are focusing on the delay. What we're focusing on here is the delay in challenging the 2020 notice. In brackets, if it ever was challenged.
Yes. So it was my principal submission that no application for an extension of time has been properly made. But so to speak to Bennett, I say it's right that I look at and deal with what evidence there is on the question of delay, the reasons for it, and whether it's justifiable in the circumstances.
Yeah.
And bearing in mind that the liability notice's job is to tell the developer or the person potentially liable of their liability to SIL, it is crucially relevant in this case that Mr. Brathwaite assumed liability for the 2017 permission in 2018. It is crucially relevant that Mr. Bennett filled out a SIL Form 1, giving the authority the information they needed when applying for the 2017 development, but didn't do that for the 2019 permission. It is crucially important, therefore, that both Mr. Brathwaite and Mr. Bennett, who'd been engaged on this project since at least 2017, indeed Mr. Brathwaite speaks about originally it was going to be a care home. Your Lordships will recall from his witness statement he's owned the site since 2010. Originally it was going to be a care home. The residential proposal came later and was dealt with by Mr. Bennett. And on the 6th of November 2017, returning to my skeleton at 22, that principal consent was granted. And it may be helpful to look at the layout plans at this point. Your Lordships have them at page 128. This principal consent, the layout plan is at 128 of the core bundle. Which is behind, if you have tabs, it's behind tab 14. So your Lordships will see there a medium-sized residential development, difficult to, on the face of it, see how it is different perhaps to the next page, but I can draw that to your Lordship's attention. The first Section 73 application, the plan is on the following page, page 129, and close attention to detail will show that the four properties on the extreme right have moved back from the open space between them and their opposites. I don't know if that's clear. They've moved back a bit. Detailed investigations of the site showed that to be necessary, something to do with the depth of foundations, and they've been moved back in the first section 103. So, forgive me, first section 73 application. The second, how did that change? Oh, and before I come to the second, the first section 73 application, no change in floor space. So contrary to the position originally taken by the appellants, that meant no liability notice was needed because there was no change in floor space. Regulation 9.6, as it applied in 2019, before September 2019, if there was no change in floor space, your liability notice was the one for the consent before, the principal consent in this case. So no need for a liability notice in 2018. And then we get the 2019 consent. If your Lordships look closely, you'll see plots 30 and 31 have changed.
So which page are you on now?
Page 130 now.
Thank you. And what's changed?
Plots 30 and 31 are right in the middle of the page. If I can't put it more clearly than that, just to the left of the square.
They're to the west of the water pumping station.
Indeed.
And how have they changed actually?
And there's a sort of change in arrangement that was designed to give sufficient room for the road to be made up to adoptable standards.
Yeah, which it wasn't before. It was too narrow. But now it was widened, so the plots.
The result of that change increased the floor space by 3.84 square metres. How would a collecting authority know in 2020 which permission has been implemented without information from the developer? It wouldn't. How would the collecting authority, how would the charging authority, collecting authority, how would the council know that a liability notice was needed? Well, in ordinary cases, Sil Form 1 is produced, and I'd ask your lordships to go to the authorities bundle.
So just pausing so that we all move at the same speed. Section 73 confers on the local planning authority the power to grant a planning permission which stands on its own as a planning permission and does not displace a previous grant of planning permission. Correct?
Yes.
Therefore, there is a choice for the developer,
Yes.
even if he gets his Section 73 permission.
Yes,
That's implicit in what you submitted to us just now.
and
So
I
he's
should have
got
made it
two.
explicit,
He's got
yes.
2 planning permissions, and he can elect which one to implement.
Yes.
You-
Hence that
you're
corresponds-
also implicit in your submission, I think, is the proposition that, of course, he may commence his development by doing groundworks in a particular part of the site, which are nowhere near plots 30 and 31, for example. But also implicit, I think, in your submission is that in this instance, the authority was not told which which permission was being implemented.
Indeed. The letter that my learned friend took your lordships to of the 19th of June 2020, final paragraph, asks for confirmation on that point.
Sorry, which letter?
It's the letter of the 19th of June 2020.
Yeah.
It may be worth just looking at it for that point. And
Do we need the drawings anymore or not?
we don't need the drawings anymore.
Okay.
So the letter is at page 105. And it's at the top of 106. That the authority said, furthermore, it's noted that a Section 73 application under planning reference, and that is the 2019 consent, was approved on the 7th of February 2019, amending plots 30 and 31.
Yeah.
This, the authority lately came to recognise, changed the floor area, and appropriate sill forms should have been submitted. As the development has commenced, a default liability notice will shortly be issued. Could you please confirm urgently which development has been implemented to enable us to issue the demand notice in respect of the appropriate permission? So they knew they had to issue a liability notice at that point.
Yeah, well, that.
But which was going to be which consent were they going to fix the demand notice to? They knew that either of the 2 previous consents would be.
Well, yes. On the question raised at the end of the letter, depended the question whether or not to serve another liability notice.
No,
No?
my lord, no, with the greatest of respect.
Because
once it was clear that the permission involved a change of floor space, a new liability notice was needed.
in any event,
Which is why I concede that the liability notice was inevitably late. And at this point, I've done some work and will do more work to explain that there was a degree of culpability on the part of the appellant. It wasn't entirely the council's fault that no liability notice was served at the right time. But once it learned that, oh, this does involve a change of floor space, late, I admit. On the 19th of June, it said, right, so we need to produce a default liability notice. A default. I don't know why they use that language. late liability notice. We need to produce a liability notice now, but we don't know which liability notice to use for the demand notice that we need to serve, because the new liability notice will be different to the 2017 liability notice. And if you implemented that 2017 consent, then our demand notice will be different to if you implemented the 2019 consent. Then we'll serve a different demand notice. Does that make sense?
Yes, it does. I think, yeah. All right. Yeah, it does.
It does make sense, and I'm grateful to you. But what I'm not understanding at the moment, it's my fault, is why they were required to issue a second liability notice if in truth it was the 2017 or 2018 permission which was being implemented on the ground.
Yeah.
Because, as my learned friend says, in an ideal world, you grant consent, you produce your liability notice, you give the developer absolute certainty over if they implement this consent, they will pay this much.
And you had back in 2017.
But okay, in this case, the difference in amount was marginal. But the regulations are working with the fact that the amount of floor space change might be significant, and the amount of sill might have an influence on which one they decide to implement.
No, I understand all of that, but if in fact they were not implementing the 2019 permission, then at the moment I don't understand why they're required to issue a new liability notice. But it may be that that's what the law requires, and there it is.
Is it because what triggers the requirement for a liability notice is the permission itself, not the election of the developer which permission to implement? So in any event, once they'd got their Section 73 permission, and there was this, actually in the context of the development as a whole, very small increment in floor space, they had then, for that reason, under the scheme, statutory scheme, to issue a fresh liability notice. They would not have had to issue a fresh demand notice unless it were clear that the developer were implementing that permission. I think that's right.
Yes,
Indeed.
that's
exactly right. No, and
can I just ask, because I don't fully understand these things, for my part, but at what point does the developer have to commit to implementing one rather than the other? You made the point that the only change is a small change to plots 30 and 31, and it may be that you could build almost the entire development before you got around to choosing which structures you would put on those plots. So when do you have to, as it were, nail your colours to a particular mast?
So the nails might be moved, but you do need to serve a commencement notice, and that identifies a liability notice, which identifies a planning consent. So when you commence under the sill regime, you do need to tell the council which
you might have to change your mind later, but it would be a change of mind.
And if there is a change of mind, that may or may not be possible. Your Lordship will.
Can you serve two commencement notices?
I'm sorry.
Can you serve two commencement notices, one for each permission, or does that expose you to two lots of sill?
Well, that's an interesting question. That is a very
anyway,
interesting
it's not. All right, it doesn't arise. Let's not worry.
In normal planning, if I could just, if you allow me, just to test this with you, rather than tell everybody what I think the position is, but the position is this, isn't it? That in the normal operation of the planning system, you can have 2 or 3 or more planning permissions for the same site for different developments on it, and your election is not forced upon you until you come to the point of doing something that renders permission A incompatible with permission B or C. At that point, you have de facto made your election. That's the normal operation of the planning system. We're not talking about the normal operation of the planning system here. We're talking about the overlay of sill upon it. And the answer you've given, therefore, is the relevant answer to my Lord's question. It is because there has to be a commencement notice that nails your colours to that particular mast. at that particular point, even if you haven't practically reached that moment of election for the purposes of the normal planning system.
Indeed, and
Well, that's
and
very
given time
educational and helpful for me.
That was a question.
I will go away and think about how you change your mind within the SIL regime. I'm sure it would be possible. But
Anyway,
on
we're not
facts
really
of
concerned
this
with that.
case, no commencement notice, and in June of 2020, you can hear the authority in that 19th of June letter saying, tell me which of your permissions you've implemented, because that will tell me what SIL is due, because I'm going to have to serve a demand notice, because SIL is due in full on implementation of a given permission. And I just, to talk practicalities rather than law just for a second, in the authorities bundle at tab 5, Lordships will see a blank SIL form 1. Now, for the life of me, I cannot find any regulation requiring the completion of SIL form 1, but the planning portal tells developers that they have to fill this out. So, what it does in a practical sense, and I'm not making a legal point here, I'm making a culpability point, a human point about the knowledge that Mr. Bennett and Mr. Brathwaite had about the workings of the SIL system and what they chose to do in 2019. So, Form 1 sets out is submitted with the application for planning permission, and it gives the planning authority the detailed information it needs to know whether SIL is payable and whether a new liability notice is required. I wasn't proposing to take your lordships to any particular part of it, but your lordships will see there's the section for indicating that you want to apply for an exemption or relief. There's floor space information. There's other information that assists the authority in calculating the SIL for that development. This form was completed in 2017. This form was not completed in 2019. Had it been
Not completed in 2019
or 18, when the application that was permitted in 2019 was made.
Not 2019, 18 or 19, yeah.
And had it been, look, this is not a legal point, but had it been, the local authority might well have produced a liability notice right away, because it would have been plain as day that a change in floor space was involved. And therefore that a new liability notice was required.
But there's no regulation that maps onto this form, or onto which this form maps. Yeah, strange.
So there it is. For what it's worth, this is not a case of on which the rights and wrongs of the situation that we found ourselves in 2020 are all on one side. Rights on one side, wrongs on the other. There is a degree to which a mess was made of the legislative scheme and the council, to which contribution was made by both sides. No assumption of liability, no commencement notice. No commencement notice because there was no liability notice, but no liability notice because there was no SIL Form 1. A mess was made. And the developers who knew that SIL in approximately £1 million was due to be paid on the 2017 development went ahead in August 2019 and said nothing about it. Didn't take the legal advice that what should they do, or didn't ask the council what should they do. 2020, we have this exchange, 19th of June, and then the exchange in which a request for instalments is made that Malone and Friend took your lordships to 24th, 25th of June. And then the notice is 30th of June, liability notice, no demand notice not imposing any interest at that point, although the regulations would have required interest from the 2nd of August. So there's a degree to which the council tried to work with the appellant and produce a workable solution, given that Sill was liable. The appellant knew Sill was liable. The appellant wanted help with the timing of the payment of Sill, and the council worked with them in a time of COVID, encouraged to do so by the government, and produced the instalment plan. And that is the starting point for the time to run against any application for judicial review. If the appellants were not happy with the lawfulness of that 2020 notice because it came too late, this court should expect of them a timely challenge, because what instead happened was, as we've heard, and I'm repeating myself now, even 6 months later, Mr. Bennett saying, we're committed to paying Sill. And then the very month after that, not challenging despite legal advice that an error had been made. And not challenging for nearly a year, even after that January 2021 realisation. In the context where the inspector, as has been discussed, and is now common ground, now, had no jurisdiction to quash the liability notice. My skeleton. Was I going to trot through the delay points?
Can you just help me with one thing? As I understand it, there was no obligation to impose a surcharge.
No.
That was discretionary.
Yes.
So if you had not imposed a surcharge in your discretion, because it's
be here, my lord.
no, might you have gone through one of the other enforcement mechanisms? For example, applying for a liability order, things of that sort.
Yes.
So in a sense, it might be said that it was only because you, in your discretion, imposed a surcharge that there was then the appeal to the appointed person, whose decision said what it said, which in a sense has given rise to the argument that we're now able to come to the High Court and apply for judicial review.
Yes, even worse than this, my lord, and I accept entirely the situation that you posed. Even worse, though, even more extreme, an illustration of the irony of this situation. If the council had not produced a new liability notice in September, seeking to correct that which it could correct, namely service on Mr. Brathwaite himself at his home address that he had complained about to the inspector, then there'd be no argument that we start from September, or that the 2020 notice ceases to exist. It ceases to have effect, by the way. And I'll come back to that.
Yeah.
It hasn't ceased to exist.
No. Well, you make that clear distinction. Yeah.
I did touch on the absence of a Sill Form 1 at 28 of my skeleton. I think that by taking your lordships to that form and the points I've made about the way in which Section 73 works with the assistance of Lord Justice Limbalom, or the senior president, I'm sure I should refer.
Doesn't matter, don't worry about it.
We can skip through to, I've touched 32 and 33, I've touched on that exchange, and 34 of my skeleton, and the notices at 35. And I would just like to say about those notices, the council had a power to impose a surcharge at that point. The council, in the Trent case, Hartsmere, did at that point. No surcharge was imposed. So we're thinking about what the actual prejudice caused to this appellant by the late service of the notice, that is relevant. No interest was added either. So what in fact happened was that an appellant that hadn't assumed liability, sorry, a developer that hadn't assumed liability and hadn't served a commencement notice and therefore didn't benefit from the instalment plan, did not pay nearly £1 million in SIL in August 2019 when it was due, and with no penalty whatsoever, was simply asked to pay it nearly a year later in June 2020, and was given until September 2023 to pay the full amount. The instalment plan was extremely generous to the appellant.
So where do we see that in your skeleton at paragraph 35?
Yes,
It
at 35.
Yeah, 35.
I'm sorry, it was September 22 when
Yeah,
we last
that's
installed.
what I thought.
Yeah, so there was in effect an interest holiday.
Not only an interest holiday, but if you know you're going to have to pay about £900,000 as part of your development, and we know they knew that because they secured a reduction in the affordable housing required because of the viability of the development. There's a viability statement in the papers here.
Which would have factored in SIL.
Which explicitly says, I can't negotiate SIL, so please can I have a reduction in the number of affordable homes I provide? Yes, permission granted, liability assumed in 2018, and then in 2019, when you implement this marginally different development, knowing that you're going to have to pay nearly £900,000 of SIL, you have the benefit of that £900,000 for another more than a year, and then only have to pay it in instalments over the following 2 years.
So your submission would be that in this case, on the facts, the prejudice flows in the other direction.
Well, certainly the prejudice to good administration and the council, if the judicial review is allowed to proceed and is upheld, is considerable. Yes.
Well,
but allowances were made. Sorry.
Well, it's maybe a false concept anyway. But the if we want to put it this way, the detriment to, if you will, to the public interest, if the affordable housing level is calculated on the basis of a viability assessment which factors in SIL as a negative, so they provide less affordable housing, then they don't pay SIL, or they don't pay. There's a period when they don't pay £1 million worth of SIL without penalty. They're asked to pay that a year later or so, and then they're given another period of grace until 2023 before they actually have to pay it.
Yeah, I'm reluctant to talk about prejudice because this was a proposal by the authority, whether or not consciously.
Yeah.
It was done in the context of it's already, as I've always admitted, made a mistake in not issuing a liability notice sooner.
No, this doesn't excuse the errors made by the council. It is simply to put those errors in a context.
Indeed. Well, no, to some extent it does, in the context of this judicial review, excuse them, because it shows that, quite contrary to the case in Trent, when Mrs. Trent had irretrievably lost her self-build exemption from SIL because she didn't serve a commencement notice, because she didn't have a liability notice. In this case, the council took a really pragmatic approach, accepting some detriment to itself in drawing the line under events in June 2020, offering a generous instalment plan, and doing without the money to fund local infrastructure for a longer period, giving the appellants, the developer, the ability to use the 900,000 to get the development going and to sell the houses so that they could pay the sum.
Yeah.
So it was a pragmatic
Yes.
compromise at that point.
And the instalment plan comes at or about the same time as the 2020 notice, but the reduction in the level of affordable housing comes much earlier, as I understand
Indeed.
it. Yes.
Yes, before the grant of planning permission, and
Yes.
it's justified the grant of planning permission on the understanding that SIL would be paid,
No, I understand that.
and that therefore,
And just pausing for a second, you mentioned the self-build exemption. You are familiar with the decision of this court in Gardner,
I am indeed.
and I'd wondered why there was no citation of that case, and I worked out once I got beyond the amour propre of the situation that it wasn't relevant.
It's not directly relevant,
No.
and in my respectful submission, it was simply the application
Yeah.
of that particular regulation.
Yeah, no, I'm only mentioning it because I wanted to be sure that both sides were familiar with it. It's a relatively recent decision of this court,
Yes,
but specifically on the self-build exemption.
yes. I mean, one could. I'm not sure whether my lords are all familiar with that case, but what it does underline, and I would suggest, it was a case in which the court gave full effect to the wording of the regulations, carefully construing the circumstances in which self-build exemption was available. Was it a relief?
It's a relief. It was the self-build exemption, I think, properly so called. Yeah. But yes, but it's not. I wasn't suggesting that it was relevant. I was only making sure that you had both considered whether or not it was relevant.
Yes, I didn't feel it was. But,
Fine.
no, this case, in my respectful submission, turns on its particular facts and the degree of the degree to which the error made by late issue and service of the 2020 notice can properly be brought to this court this late, but also, if it is brought before the court this late, the degree to which that, in the end, caused the appellant significant prejudice such that it should be declared invalid and quashed. I'll be repeating myself, but just my primary submission is there isn't really a proper application for an extension of time. So my submissions on the substance are almost that they're for the avoidance of doubt and speculation. I didn't want it to be assumed that I leave that point.
Can I just clarify one point? Forgive me. If we look at the bundle of authorities at page 9, authorities, page 9.
Yes. Yes.
Section 31, but not the provisions we've been looking at today. It's a much older provision, subsection 6. Sorry, do you have page 9? Yeah, section 31, subsection 6, very familiar to you. Where the High Court considers that there has been undue delay, the court may refuse to grant leave or any relief if it considers that the granting of the relief sought would be likely to cause ... would be detrimental to good administration. Do you rely on that?
Well, yes. In that, a substantial proportion of the SIL due has been paid, and would need to be repaid.
Yes.
And the degree of delay here, when we're looking at this amount of money for the funding of local infrastructure, the uncertainty that is caused by whether or not that is available to the council, has caused detriment to good administration. check my notes. I don't know whether I need to go to the ways in which I would distinguish the decision of Mrs. Justice Lang in her earlier case, Trent, but I've set out 3 at 63 of my skeleton.
Right. Well, to help you, she distinguishes it herself in her judgment.
Yeah, and at 25, paragraph 25 of her judgment, and 30 to 31. And just very briefly.
This is your skeleton argument now. Sorry.
At 63.
Thanks. Yeah.
And the point my Lord Justice Singh made about detriment to good administration might also be summarised in the immediately preceding subparagraph of my skeleton 7, where I draw attention to the objectives of the civil regime and the delay. And that comes at the end of a series of subparagraphs in which I spell out what I see as the principal reasons why the court should decline to exercise its discretion and allow the case to proceed. Would now be a good time for me to say something about ceases to have effect, my lords?
Yes.
This I deal with in my skeleton from paragraph 66. And I do submit that the focus on this provision is something of a distraction. The 2021 notices effectively replace the 2020 notices, and to ensure that there's no confusion about which has effect in the real world, the regulations provide that those earlier notices cease to have effect. It would have been perfectly possible to say ceases to exist. The legislative purpose of doing so escapes me. One doesn't, if Melania Friend is right, one has to read the 2021 notices as rendering the 2020 notices as if they'd never been made. And the purpose of that is really beyond me.
I'm not sure I'm following this. Surely the burden in that phrase, cease to have effect, the burden is on the word cease.
Yes.
In other words, it no longer has effect.
Yes.
Not that it never had effect.
Empty.
That's all you need to establish, isn't it? And surely it does cease to exist for the future, but it doesn't matter on your submission. Is that right, or have I misunderstood?
That's if I may say beautifully put, it summarises I'm finding this very difficult because to articulate, because that phrase really encapsulates it. It existed until the notices, the 2021 notices were made, and ceases to have effect afterwards. But it doesn't mean it ceases.
But something can, my lords, the thrust of my lord's point, as I take it, is that something can only cease to have effect if it does have effect. And moreover, it ceases to have effect at the point at which it ceases to have effect. Not at any other point. It can't cease to have effect having had no effect,
and
or having ceased to have effect at some earlier point.
And
So to
how
make sense of the English, it has to have had effect up to the point of it ceasing to have effect. I mean, as my Lord puts it, that's the clarity of the language.
So I will take it, unless there's any questions I can answer in relation
But is
to
that,
that.
I'm
I'm
sorry,
not
let
gonna
me just
take your
pursue
Lord's-
that. It is important, isn't it, for your submissions, or is it not, that it was, the 2020 notice was therefore in effect, albeit it could have been challenged, but wasn't. It was in effect up to the point of the 2021 notice.
My Lord, I don't think so. Which is
It
the
wasn't.
reason this is a distraction. No, I don't think it's so important for my submissions. My submissions depend on the grounds for this claim first arising in June 2020, and whether or not something happened to that notice, rendering it void or gone or of no existence. That is when the grounds for this claim first arose.
Yes.
And there is no proper excuse for waiting until the notices were.
No, I understand. I understand that point.
And it does sometimes happen that a claimant has a good reason still to challenge something which has been revoked for some reason.
Yes.
It's not common, but sometimes the courts do entertain a claim for judicial review because it can matter. I was sitting in the Constitution which decided the case of Dolan, which was a challenge to the first lockdown regulations. And they were being changed so quickly, for understandable reasons, that inevitably any application that was ever made to the court was bound to be out of time, in the sense that it was targeting something which no longer existed. But nevertheless, we felt that it was appropriate in the public interest to say something about the vires of the initial lockdown regulations. For obvious reasons, it was important to everyone in the country to know whether what had happened was lawful or not. So the mere fact that in September 21, the 2020 notice ceased to have effect, or for that matter ceased to exist, on your submission, wouldn't in principle prevent the court from entertaining judicial review proceedings about something which has been, by law, rendered ineffective.
Indeed, and the court, as happened in Arnold White, the case cited by my learned friend, the court needs to look, in my respectful submission, for what the substantive complaint is about. And the substantive complaint has always been that the 2020 notice was late. But that argument was only presented 18 months after the notice was issued.
Now, I understand that, but can I put to you what I think is the fundamental submission for the appellants? I think it is that we haven't challenged the 2020 notice. We have challenged the 2021 notice. And we challenged that within time. And the 2021 notice they submit is a long time after February 2019. So it can't be said to have been served as soon as practicable after February 2019. And therefore, the 2021 notice falls to be quashed by this court. So what's on the face of it, that looks like an impeccable series of propositions.
Yes,
what's wrong with that argument?
But of course it isn't, because yes, the 2021 notices were not served as soon as practicable, but we have Regulation 65(5).
Right.
In addition, so may at any time.
Yeah.
So the revised notice. But in addition, when your lordships acknowledge, as we all must, that this notice, the 2021 liability notice, was not served in accordance with Regulation 65.1, either we look to 65.5 and or we say, okay, so in breach of 65.1, but the appellants have known about liability at least since 2020 and probably a long time before that. And therefore, if there is a breach of the regulations, I'm going to exercise my discretion and not quash this permission.
Yes, but I think that's the discretion point. But I think even before one gets to discretion, I think your first submission is that this does properly constitute a revised notice.
I do.
And that doesn't have a time limit because it says at any time. And then, well, we won't go over again the arguments. You say that it builds upon the earlier 2020 notice. And because the 2020 notice was not challenged or quashed in time, it has to be treated as being still valid. And so the argument, you say, falls away.
Indeed.
Thank
Yeah.
But also, I'm not sure I need trouble the court very much longer, unless
No.
there are passages of my my skeleton that I ought to take the court through.
Well,
May I just check my note of what was...
In the exchange you've just had with my lord, and in the foregoing submissions about delay and its ramifications, you have, I think, encapsulated the essence of your argument.
I believe so.
Yeah. We're all, I think, of that view.
May I then
So to
just
answer your
quickly check
question,
my
yes, of
note?
course, yes, but we don't, I think, unless you wish to submit more, require more of you. We have in mind, of course, the submissions you've made on paper.
Yes, I'll finish with this, if I may, that if these notices, the 2021 notices, are quashed, then the 2020 notices revive. If the notices are not quashed, the basis on which, the only lawful basis on which the council can pursue the appellants for civil is in the demand notice served in 2021, which starts the clock on interest at that point. Those are my submissions.
Right, thank you.
No, that last point is a positive submission that the council would not be entitled, if the 2021 demand notice and liability notice stand, to claim backdated interest. So it goes perhaps a little further than we went before, which was that it was unlikely that they would do so. But I think your last submission was not entitled.
So the only basis on which it is currently possible to recover CIL is that demand notice. Now there are if things change, maybe the development will change before it's finished. Maybe a new demand notice is required. Maybe a surcharge is properly recoverable. But any future changes to that demand notice,
But if things change on the appellant's
by-
side, that's one thing. But if nothing changes on the appellant side, then your submission is as you've just made it.
Indeed, if nothing changes, it seems to me that this is a course of conduct, a public representation about the approach being taken, that a public authority would be in very great difficulty resigning from.
Thank you very much.
Right, thank you. Yes, Ms. Cahoon, your reply.
Thank you, my lord. Just a few points, and I'll try and deal with them in reverse order. It might help your nose, I don't know.
Yeah.
But dealing with that last point, my lord, there have been a number of points at which my learned friend has suggested, firstly, that demand notice stands somehow separately from the liability notice. That cannot be the case. Liability notice sets the full amount. The demand notice can add charges, including interest and surcharges, but it cannot exist on its own. It has to be parasitic on a liability notice. So if there is any suggestion that the demand notice, in effect, is what would stand as a measure of what the council will do, that cannot be right. It has to be, what does the liability notice say? What does the demand notice ask for currently? Now, my lords, the 2020, it was right, the December 2020 surcharge demand notice clearly charged interest. And it is quite possible for this authority to serve a second, or well, it would have to be a revised notice if we're going to rely upon the existing liability notice. But it is quite possible for the council to reintroduce that. The notion that this council has somehow gone out of its way to avoid charging interest or surcharges is simply false. The council, we say, was at fault. And indeed, when they approached the appellant in June of 2019, it is also false to suggest that somehow that is all in the appellant's lap for not filling out SIL Form 1. It's not required. And not sending them an assumption of liability notice in relation to this planning permission. It is not required to do so. It is a matter that they can choose to. The SIL regulation, SIL regulation 31, which I took you to, which is at page 46 of the authorities bundle. Makes it clear that it's on the basis of a wish. A person who wishes to assume liability must serve an assumption of liability notice. It is not a requirement. And the reason that it doesn't have to be a requirement is because the local planning authority is to provide the information from its own planning decision to the charging or collecting authority, upon which then to serve a liability notice. There is, it is, whilst it might have been helpful, in my earlier submissions, the point I was trying to make was that the developers don't have to serve an AOL, assumption of liability notice. What they do is get their permission and wait to be told what the liability is.
They don't have to, but they may disqualify themselves from, for example, deferred payments if they don't.
But my lord, again, I was just coming to that point, because they can assume liability after they've got a liability notice. The the liability notice does a number of things, but it doesn't. So, if you look at Regulation 65, back to page 50, it must be issued on a particular form. It must include a description, chargeable development, state the date on which it was issued, etc. State the chargeable amount. And my lord, I don't want to read it all out, but in Trent, Mrs. Justice Lang went through all the points that are important about a liability notice.
May I just make something absolutely clear? I do apologise for interjecting, but there are people listening that may need this clarification. I recognise that the demand notice 2021 states that failure to pay may involve an interest charge. Failure to pay may involve a surcharge, and therefore, if SIL isn't paid, then there may be additional charges imposed, as set out in the 2021 notice. What the 2021 notice does not envisage is the backdating of interest to 2019 and the retrospective imposition of charges. It resets the clock at the 17th of September 2021. I hope that's clear.
My lord, that is not what the regulations say about mandatory interest. It goes back to the date of commencement. It's got nothing to do with measuring against the liability notice. And that is what was reflected on the face of the 2020 surcharge notice.
Subject to an argument about the Human Rights Act.
Indeed, but that, my lord, is a separate issue, which would be the subject of challenge and would be on the basis of the arguments that we're having today.
Well, it would only be this. Sorry, forgive me for interrupting. Yes. You only have to challenge something if a local or a public authority takes issue with it. Every indication that we've had this afternoon is that they will not take issue with that.
But they did before.
Yeah, I understand that.
And they were entitled to. So,
I'm sorry, I asked my learned friend to make it clear that the interest charged in December 2020 was only from the date of the instalment payment that was missed. The Council did not take the opportunity of backdating interest to 2019. So the authority sets out its requirements, and if they are breached, then yes, from the date of the breach, interest may be applicable.
Let me take you to surcharge notice itself, my lord, which is at page 127 of the supplementary bundle.
I'm sorry, which page?
Page 127 of the supplementary bundle. My lord, this was the example that I took you to show you that interest does go back to the date of commencement. So we can see on the last page, page 132, late payment interest, 3rd of August 19 to the 29th of December 2020. So that is where it's dated back to. And that is because that is what Regulation 87 requires. There is no, I mean, we can look at the Regulation 87 itself. And Regulation 87.1 says where a person is liable, etc., he must pay interest on the relevant amount. Late payment interest must be calculated for the period starting on the day after the day payment was due. and the date that payment was due is the commencement date. If Miss Townsend's submissions were correct, then this notice would have gone back to the date of the liability notice, not 2019, if a different due date was supposed to be imposed. It is clear, SIL, in other words, the SIL, the levy in itself, is from the date of, what we say date of commencement, and that we see from Regulation 71. Development is due in full. Sorry, that's at page 60 of the authorities bundle. So, my Lord, we don't accept that there is potential. Well, if they do, then they're not actually complying with the SIL regulation. So we don't accept that there is a limited, or indeed any power to limit when interest dates from. In terms of the course of conduct, my learned friend was very keen to say, well, you know, the council in effect has been very generous. But my Lord, the instalment plan, we say, could have been available to the appellant if the liability notice had been served early enough. And that instalment plan may well have been as generous as this instalment plan. So we don't accept that there has been some over generosity on their part. And my Lord, just in terms of the ceases to have effect point, I would say that it is the first time that the council has acknowledged that the 2021 liability notice does not accord with 65.1. It has always been the case that they've suggested that it does accord because the 2020 liability notice renders it valid.
So that remains my primary case.
Well, my Lord, I noted...
Regulation 65.5.
But my Lord, turning to 65 itself, there is this tension between, and I know we've dealt with it before, but there is a tension between what is meant by a revised liability notice and what the effect of 65.8 is on a prior notice. But my Lord, it must be the same, because there can be only one liability notice. So even if there is a revised liability notice, the earlier liability notice must cease to have effect. I think, my Lord, it may be that the question over ceases to have effect sparked attention, at least from me, because Mrs. Justice Lang said it means it didn't, it continued in effect to exist, and we don't think that can be right. But I think from listening to Ms. Townsend's submissions, we are in effect as one. It's just what that means to this case. I don't think there's any suggestion that that the 2020 notice continued some kind of legal life beyond the 2021 notice. My Lord, coming back to the issue about demand notices, I noted an exchange between my learned friend and Lord Justice Mayles about what would happen to what would happen if that no demand notice was well, in fact, if the demand notice stayed the same, my lord, the demand notice has to be parasitic upon the original, or has to be parasitic on a liability notice. So if the liability notice changes, the demand notice must change. My lord, I don't intend to discuss or challenge the other enforcement provisions. It's not clear from my learned friend's submissions what would flow or what potential prejudice or otherwise might flow. I understood the point that my Lord Justice Singh was raising was whether you could return in effect to whether these notices are valid. The points that Mr. Townsend drew attention to deal with circumstances of the case, so it may well be that they could, but it's not entirely clear, especially in the face of a judgment like this, that would be possible. So I in effect repeat what I was saying earlier. And my Lord, just perhaps to draw all these points together that were made about the history of Mr. Brathwaite's involvement and that of his architect, coming back to, in effect, to the assumption of liability point, the council it is entirely within the council's gift to know what additional floor space had arisen from the second Section 73 planning permission. It did not need to wait or seek further assistance from the appellant in the way that it suggests. But my Lord, we do say that, of course, they did assume there was an assumption of liability at an earlier stage. So again, to suggest that somehow the appellant was playing fast with the system and not bothering to address this point is not right. And lastly, the point that's made about the continuing the implication that prior to the issue of the surcharge notice, that what was being declared by Mr. Bennett. Forgive me, let me get the right references. Page 1135. Page 133, my Lord. The letter that went on the 31st of December in response to Mr. Bennett saying, in effect, we've got problems and require flexibility. The response from the council was very clear. It says it should be noted that your client commenced the development several months prior to the start of the pandemic, and had the correct notices been submitted, would have paid the first instalment by October 2019. That was the attitude of the council at the time, not, oh dear, we made a mistake, we didn't serve the notice on time, we're going to indulge you in a very generous instalment package. That is not what was being said by the council. Your client should have ensured finance was in place to cover the SIL liability from the outset and not to be reliant upon sales or the first instalment of it at least. Your client made no attempt to deal with SIL liability, and when the council agreed to a bespoke payment, to assist, your client failed to adhere to the agreed arrangements. So that was the council's attitude, not the one that I'm afraid Ms Townsend is trying to sell the court, that they were bending over backwards in effect to help the Brathwaites. There is a suggestion and recognition with priority is that your client's failure to pay doesn't impact upon purchases. However, it does say we might consider enforcement action to stop the development at any time. And my lord, that is what triggered, in effect, the fear from Mr Brathwaite and the instalment payment that came subsequently. So my lord, that is the context of what was happening at the time that the surcharge notice was issued. And as we say, the council did not recognise that it had made a mistake until after the inspector had made his decision, which clearly said they had not complied with sub-regulation 65. And my lord, we do say that that is an important decision, and that was a potential decision open to that inspector. And if the council had not liked it and thought it was unlawful, they should have done something about that. So my lord, those are my submissions. Thank you. Thank you very much to my instructing solicitor. The question about what happens if you choose between two or more planning permissions, there is abatement provisions which allow for the differences to be calculated, and those are regulation 74A and 74B.
That's very helpful. We don't have those, do we, in the clip?
We don't.
It doesn't matter, we can look them up.
I don't even think they're in.
There's no need to supply them, that's all right. But we've got a note anyway. That's the they're called abatement provisions.
Abatement provisions, yes.
Right, fine. No, we can look those up.
Unless I can help you any further, those are mine.
Thank you very much, Ms. Goodwin. Well, thank you both very much, and those who've assisted you for very clear arguments, both written and as presented to the court orally today. It will not surprise anyone here to hear me say that we shall reserve our judgments. They will be handed down in due course. Before they are handed down, a draft will be circulated for typographical and obvious factual errors to be corrected, and only that. I draw your attention specifically, as will the draft judgment when circulated, to the embargo arrangements and the importance of strict compliance with them and the consequences of their not being complied with. That will be familiar, I'm sure, to counsel and those instructing them here. Thank you very much. I should point out, incidentally, I should say this, the order will be agreed in draft if possible, but any submissions that have to be made about the order must be made at the time of hand down, please. Thank you.